Hey everyone, this is Sahil Malhotra, principal attorney at Drishti Law. Whenever I'm doing client intakes, more often than not, there's some kind of confusion about like something that can be copyrighted versus that something can be trademarked. So because that confusion generally exists, I just wanted to hop on here and just explain the difference. What do I need more, trademark or copyright? What is the difference between trademarks and copyrights? So let's talk about that. Trademarks protect mostly brand names, logos, slogans, and more. Trademarks provide exclusive rights, amongst other legal protections, over the use of your brand in the marketplace. At the same time, copyrights protect creative work, including artwork, music, movies, books, etc. Copyright can apply to anything that you create, such as writings, films, photography, as long as that whatever you create is original and doesn't copy another person's work or idea. And also remember, it protects only the expression of the idea, not the idea itself. A trademark protects your brand by preventing others from using your company's trademarks, which could impact the sales of your products or services. A brewery that wants to protect the name or label of the new seasonal beer that they're about to release might want to apply for a federal trademark, although they could protect it as original artwork as well if it is creative enough as a copyright. But I would more often not advise that person to apply for a trademark registration. A writer who wants to protect an original idea or an original screenplay should apply for a copyright registration at the US Copyright Office. There are times, though, when a combination of federal copyright and trademark protections apply for your brand or original creation. A cartoonist with an original idea for a series that includes characters, logos, names, merchandise, and even an original screenplay for a comic strip or a movie. They should pursue multiple types of intellectual property protections. It should start with protecting the name, logos, and characters as trademarks, but you can also protect the characters and screenplay as a copyright. To better understand what intellectual property protections apply to your venture, you should always consult an intellectual property attorney before starting the process. Now let's talk about why are trademarks and copyrights so important. Under current US law, there are a variety of intellectual property protections available to small business owners, entrepreneurs, and creatives. Intellectual property protection provide legal benefits that give you the exclusive right to develop your brand identity or protect your artistic work. Trademark and copyright registration processes are two common ways for individuals and small businesses to protect their brands and original works from unauthorized use. This especially comes in handy when there are bigger companies who might try to monopolize on something original that you have created or on a product that you have created. As I mentioned earlier, trademark protection is for brand owners. A trademark is a brand name, logo, slogan, or any other source indicator that can be registered by an individual or business at the United States Patent and Trademark Office. US trademark law protects distinctive marks that are used in commerce. The trademark holder has the right to stop others from using a similar mark in connection with similar goods and services. A registered trademark is not just for a business name or logo. It can be the overall brand identity consumers associate with their goods and services. An example of this would be Apple. The company brand Apple is a federally registered trademark and cannot be used without the authorization of Apple in connection with its goods and services. In this case, I would not be able to register a mark that is the same or similar to Apple's branding, name, logo, slogan, or anything in connection with music streaming, TV streaming, phones, TVs, tablets, and anything else that Apple currently sells or could reasonably be expected to sell without violating current US trademark law. Apple protects its names, logos, colors, product packaging, and designs, and much more through a robust trademark application process. But brand protection through a federally registered trademark is not limited to major companies. A comprehensive and proactive brand protection strategy helps small businesses and entrepreneurs carve out a niche and separate themselves from the crowd of established brands. A basic brand protection strategy usually involves the following: trademark applications. The registration process is under the authority of the USPTO. Monitoring and policing services. Your trademark is only as strong as its enforcement, and lack of enforcement for trademark infringement can leave your brand vulnerable and its registered trademarks weak with little to no protection. I mean, that's a fact. If you do not enforce your brand's strength, it will become weaker. Therefore, working with a trademark lawyer, offering enforcement services is essential. And the third thing a basic brand protection strategy should include, although this list is not exhaustive, it is maintenance filings. Brand owners are responsible for filing the declaration of use, claim of incontestability, and renewal filings in a timely manner so their protections do not lapse. The brand owner or the trademark attorney listed at the USPTO will be responsible for the timely filings. Now let's talk about copyright protections. Copyright protection is for original works. Copyright protections include, amongst other things, a legal right that safeguards the original work of the authors. Original works must be authored by a human and be minimally creative. Additionally, the work must be in a fixed form, means it should be tangible. Be it in a hard drive, be it on a piece of paper, it needs to be in a fixed form. Copyright is an intellectual property right that protects literary and artistic works such as music, books, movies, photographs, software code, and other tangible works from being reproduced or used without permission. A copyright owner does not need to register their original work at the U.S. Copyright Office to have certain common law rights. Although officially registering the original work gives you access to federal court for copyright infringement under U.S. copyright law. Copyright registration allows a copyright holder access to the Copyright Claims Board, similar to a small claims court for copyright law matters. The CCB handles copyright disputes that claim up to $30,000 in damages. Now, Disney is one of the most litigious and aggressive intellectual property portfolio holders. They send enforcement letters and will file suit when they deem artistic creations to be unauthorized duplication of their intellectual property. In the past, Disney has informed an individual that carving a Winnie the Pooh in a child's gravestone would violate U.S. copyright law. A more recent example is Disney claiming copyright infringement by an online retailer using Disney characters for selling items such as face masks, stickers, Mickey ears, decals, keychains, hats, etc. Disney can pursue these lawsuits because they own exclusive rights to license and prepare derivative works of its original artistic creations. The owner of a copyright registration holds multiple rights over the creative work: reproduction of the work, derivatives based upon the original work. In this case, the keychains, the hats, decals or anything like that. Distribution of the copies of the work to the public. So I can't just go out there and start selling copies of Disney work without authorization of sale. Public performance of the copyrighted work. I can't start streaming Disney content for the public to see in my local park. That Disney will just not be happy about that. Public display of the creative work. Similar to the public performance, public display of the creative work is not something a company like Disney will appreciate, for lack of a better term. Now, I hope I was able to kind of talk a little bit about the differences between trademarks and copyright, and I hope I was able to give you a little bit of a better understanding of what the differences are and which protection might apply to you, and maybe both apply to you. But if you need further assistance, figuring out which intellectual property protection applies to you, feel free to reach out to me. I'll provide the link below. And, feel free to reach out to me on my phone number, 773-234-1139, or go to my website, www.drishtilaw.com. That is DRISHTI law.com. And follow me on my YouTube channel, Instagram, Twitter. And thanks for taking the time to stopping by. And I look forward to talking to you again. Thank you.